notoriety for profit around some of the original legislation that came forward with respect to these kinds of bills. And the minister may know, and Mr. Speaker, you may know, that some of the original legislation dealt with the son of Sam. And in fact, many of these pieces of legislation actually became called the son of Sam laws to deal with David Berkowitz, who was a psychopath who terrorized parts of New York State back in the 1970s. And part of the problem around Mr. Berkowitz was this whole question of whether or not there was going to be profit made as a result of him signing on to contracts for which he could profit. Interestingly enough, I believe it was in the late 1970s that New York State brought forward its original legislation, and it was very specific with respect to the ability of those who committed violent criminal acts not being able to profit from that notoriety or from contracts entered into with other individuals, with corporate entities such as those promoters of books or movies or other kinds of broadcasting with respect to the circumstances surrounding the crimes that Mr. Berkowitz had perpetrated. And I believe that it was not long after the implementation of these laws in the state of New York that many other states in the U.S. Followed suit. And I'm not exactly sure, Mr. Speaker, maybe the Minister of Justice knows better than I do, but I think there were more than 40 states and the federal government of the United States that decided that they were going to follow the example set out in New York State and implement these kinds of laws. The legislation has a kind of mixed history because my recollection, and I know there are others who have an interest in this particular area of law as well, but my recollection is in the early 1990s, the Supreme Court of the United States struck down some of the legislation. And the case that I recall was, I think, a case called Simon & Schuster, which is a book publisher, versus the New York, I think it was called the Victims of Crime Compensation or Victim of Crime Services Board. That's not, don't go looking up that citation because it's not perhaps as exact as it ought to be, but that's kind of my recollection of what happened with respect to that piece of legislation. It was what happened, of course, was that simply because the legislation was struck down in that format, the lawmakers in the United States then, of course, went to work to try and rework the law so that it would be acceptable to the Supreme Court. Oh, by the way, I should mention the reason why it was struck down was because it was seen to be a violation of the First Amendment to the United States Constitution, right to free speech. And that was the interpretation of the court. They said that it was overly broad and that created a problem in reaching beyond what the law needed to do in order to deal with notoriety for profit. So as I said, the lawmakers in the United States set to work at redrafting much of the legislation, and I'm not sure. I believe that to date, most of those have managed to survive contests. I'm not sure if the minister, and perhaps when they close debate on this, perhaps he'll be able to indicate whether or not he knows whether or not legislation in other parts of this country have been challenged, because oftentimes, Mr. Speaker, these pieces of legislation of themselves make so much sense that there aren't a lot of of challenges that come forward. I'm not sure whether or not the minister is aware whether or not there have been challenges to legislation from other jurisdictions in this province. And I note that that in this particular legislation, that it defines who can actually be affected, by the legislation, whether they're a resident in the province or whether the contract was signed in the province, and those are all jurisdictional considerations, of course, that the drafters of the legislation, I assume, considered as they were looking at this kind of legislation. So I just wanted to, because I think it is an important piece of legislation, I just wanted to try and put what happens in this kind of legislation in some kind of framework for people to understand that this is about controlling, from a public policy perspective, one of the possible consequences of a crime. And that is that those who committed that violent crime will attempt to gain financially, perhaps while they, well, in all likelihood, while they're incarcerated, and that benefit isn't necessarily flowing just to them. And I notice that the legislation deals with the whole question of who is a presumed agent of the offender. They can include spouses or former common law spouses. They would include people who have signed directly a contract or indirectly have entered into a contract for the retelling of the circumstances of the offense. And all of this is to say that I think that this is a perfectly valid purpose for this legislature to explore, to try and foreclose the possibility of that happening. And it is the kind of public policy purpose that we would expect the Minister of Justice to bring forward legislation on. So I think it was the member for Clayton Park who pointed out that this is, at this point, what we're really doing in terms of talking about this bill is just making introductory comments about the bill, and that from here it's going to move on to the Law Amendments Committee. There's going to be an opportunity for input from from interested parties in the public, and I'm looking forward, frankly, to seeing what will come forward from that. And I said I'm also hoping that perhaps the minister, kind of considering my very brief and somewhat muddled recollection of this kind of legislation and its history, at least in the U.S., I'm looking forward to hearing from him a little bit about the context that he sees this bill fitting into. So, Mr. Speaker, what I've said so far would, I think, lay the foundation for a much greater argument with respect to the reasons why we might want to have this legislation. But I'm not going to further engage in that this evening. Instead, I'm going to take my place and see if there are others who would like to comment on the bill. And I thank you for your indulgence.
Now I recognize the honourable member for Halifax Atlantic.
Mr. Speaker, and I appreciate the opportunity to speak to this bill. I wasn't actually intending to, and so I'll be very brief. But I'd like to commend this as a signal, primarily, of something that is a broader phenomenon. Why in the world do we even need such a bill? Why is there such an interest in the notoriety raised by these activities? Why does anybody want to know? I think all of us, not only those who are victims, but all of us who actually see and hear and are obligated to see, hear, and perhaps watch our children and the colleagues, the people who surround our children, being forced to see and hear the retelling of these crimes. We are all victimized. We are, in fact, victimized as a society. And the more that happens, the more there is, in fact, an interest in it taking place. And I think this is why it's particularly disturbing that a bill like this should need to come forward. Why do we really need to stop people from being able to profit, to put themselves into a market which is obviously such a profitable, such a center of interest? Yes, there's a normal human interest in cautionary tales, but we've developed it into a science. And it seems to me that when we are watching day in and day out, watching, hearing, reading, although that's sometimes more of an activity of choice, the stories of the various horrors that are promulgated around us, then we are in fact participating in a market which many of us would never have expected, would never consciously participate in. This bill is a very good thing in the sense that it says here is a market, and we are going to stop a certain part of the participation in this market. A lot of the world of this retelling of horror stories is in fact a cause of more of the horror stories. It seems to me that those who are angry from a whole variety of reasons, which may be poverty, they may be financial poverty, they may sometimes be poverty of experience, poverty of a lack of empathy, a lack of experience that has caused people to realize that in fact causing human suffering, causing animal suffering is a part of a world which we all can share, not only as actor, but in time also as patient. But those who are angry and those who are poor, whether they are poor financially, whether they are poor in experience, or some might say perhaps even poor in spirit, poor in empathy, the telling of these tales, and I should say that it's not always the telling of factual tales, but often the telling of fictional tales, gives vocabulary to that anger. And we need to accept a responsibility if, as a society, we are going to continue to teach the words, the phrases, the sentences with which to express such anger. Maybe what got me up just now to speak about this is the fact that tomorrow is Halloween. Tomorrow is this great celebration of the inflicting, frequently, the inflicting of suffering. I read in the paper recently that it's an archaic thing that certain animals and animal shelters should not sell certain animals around Halloween because it's a fun thing to inflict suffering on them. And there were, in fact, cases in this province around Halloween some time ago where terrible suffering was inflicted around this. Why Halloween? Halloween has become a thing of entertainment. And if you look at the newspaper today, there's stories about cutting up, amused stories about a parent watching her children cut up their stuffed animals and teddy bears and stitch them all together to look as grisly as possible. Some of us remember teddy bears and stuffed animals as objects of love, as places to practice affection, to practice empathy, and to practice the learning, gaining the experience of humanity, not to practice taking away humanity, taking away, and I should broaden that. It's not just humanity, it's animal existence, I mean animal in the sense of spirit. And the making of profit on this seems to me a dreadful thing in so many ways. You know, to be selling fake blood and pictures of people with various parts, you know, ways to disguise yourself as a maimed or injured person. Why are we doing this? What are we training people for? What are we training children for? Why, in fact, should we need to make a law that would prevent anyone who has actually exercised those skills from wanting to teach those skills to others? We shouldn't need to make this kind of a law, but since it would appear that it's a step along the way, then I commend it and I look forward to it coming forward. Thank you very much.
I will now recognize the Honourable Minister of Justice to close debate on Bill number 17.
Thank you, Mr. Speaker, and I'd like to thank the members opposite for their comments and their suggestions, particularly those that are around this bill. And the Honourable Leader of the Opposition, official opposition, mentioned about whether, in fact, this other types of legislation across this country have been challenged. I'm sure that the folks who drafted this and the folks in the department would be well aware of that. Certainly something that we'll take into consideration. As well, I'd like to thank the members who have made suggestions around other things outside of this bill. You know, Mr. Speaker, someone mentioned whether, in fact, this legislation was worthwhile in this province or not, and I would say that it definitely is. As we indicated last week at the announcement of our rewards program, you know, if we solve one crime as a result of that rewards program, it was well worth it. If one person is prevented from benefiting from their acts of violence, breaking the law in this country, whether it's from Nova Scotia or from Ontario, if one person prevented from benefiting from that, then this legislation is well worth it. And I look forward to the support of the members opposite passing us through law amendments and on for third reading. So, Mr. Speaker, with that, I move close debate on Bill number 17, the Criminal Notoriety Act, and move on to law amendments. Thank you.
Thank you. The motion before the House is for second reading of Bill number 17. All those in favour of the motion, please say aye. Aye. Those against, motion carried.
Bill 17, entitled An Act Respecting the Profits of Criminal Notoriety.
Order that this bill be referred to the Committee on Law Amendments. The Honourable the Government House Leader.
Thank you very much, Mr. Speaker. Mr. Speaker, I'd like to call Bill number 21, the Justice Administration Amendment 2006 Act.
Bill number 21. The Honourable the Minister of Justice.
Thank you, Mr. Speaker. Thank you, Mr. Speaker. I'm pleased to begin second reading of the Justice Administration Amendment 2006 Act, an omnibus bill. Mr. Speaker, this Act covers several amendments. For example, there are a number of housekeeping amendments to the Assessment Act designed to remove uncertainty in assessment applications to the Supreme Court of Nova Scotia. Another amendment removes references to the former county court and deals with the destruction of records and electronic exchange of information between property owners in the Assessment Services Division of Service Nova Scotia and Municipal Relations. Mr. Speaker, we're also amending the Enforcement of Court Orders Act to allow the Register of Motor Vehicles to suspend the driver's license of someone in default of payment under this Act. Other administrative amendments cover the Land Title Certificate Act, Clarification Act, the Public Archives Act, Land Registration Act, and the Vital Statistics Act. Mr. Speaker, we look forward to comments from members opposite today on this very important bill. And with that, I move second reading of Bill number 21, Justice Administration Amendment Act.
The Honourable Member for Cole Harbour, Eastern Passage.
Thank you, Mr. Speaker. I'm glad to have an opportunity to speak on Bill number 21. This is a bill that's introduced on a regular basis, which is basically an omnibus bill addressing justice issues in this province. At least once a year, if not once every session, we see a bill come forward that addresses a wide range, a motley crew of different pieces of legislation within justice that need to be addressed. And indeed, on the same day that we're debating this one that was introduced in the summer, there's a new one that was introduced today as well and has been tabled before the House. I don't know the number of the bill, but it was also introduced today. I want to speak, I guess, about some of the things. Because this is a bill that deals with justice generally, therefore deals with the principle of justice, I want to talk about something that should be in this bill. Something that I believe as a principle should be addressed, and something that I believe last week in the media, the Minister of Justice said that they were looking at, and that is mental health courts, Mr. Speaker. This is, I believe, an opportunity when we introduce an omnibus bill to address justice to also look at the need to address what I think, again, is an ongoing concern, something we've heard about in this province on an ongoing basis over the past 2 months. Consistently, though I would argue it's been happening more quietly, sort of below the radar, Mr. Speaker, and that is the issue of people who are mental health clients, who have mental health issues, who are appearing before the courts on criminal charges, where the criminal charge is a symptom of a bigger problem, which is not receiving the services and the support they need in the community to ensure that they're addressing their mental health needs, Mr. Speaker. That is what we need in this bill. That's what the people of Nova Scotia are demanding when they see the problems that they're facing in the court system, when they see people, as has been in the media, as we're all well aware, Mr. Speaker, people who have been before the courts consistently, repeatedly, because of the problems they have faced, because this government has failed to provide the services they need to ensure they're able to sustain a reasonable life in society, in our communities, without a threat of violence to themselves or others or committing criminal acts, Mr. Speaker. You know, it's a shame that this Minister of Justice in the media last week said, they must be reading our minds. We're thinking about putting in a mental health court. Yet here we are with a Justice Administration bill that does not have this. The minister could have gotten up in his second reading a motion and said, we intend to amend this, law amendments to address it. He could have, the bill he introduced today, Mr. Speaker, could have had a clause in it as well. Yet again, much like the last bill we just debated, this government wants to talk about tinkering with nibbling around the edges of justice issues, but is not talking about the issues that Nova Scotians are talking about in their coffee shops, in their homes, in their workplaces, Mr. Speaker. And in this case, the one I'm talking about is the fact that we have people who are suffering from mental health issues, Mr. Speaker, and they are not receiving the services they need in the community. It was last year that the member for Halifax-Needham fought vigorous battle with regard to what I think is called the Involuntary Psychiatric Treatment Act, an act that specifically said we're going to close more beds in hospitals, we're going to put more people into communities, and without any guarantees of the services that are required, Mr. Speaker. We warned at that time that what you are going to get is a situation where people potentially are going to be at risk of offending, at risk of danger to themselves and others, potentially committing crimes, Mr. Speaker, and yet this government, through that act, has not provided the supports and services, whether through that act or otherwise, that are needed for people like that in our communities, Mr. Speaker. People and families that suffer from mental health issues, Mr. Speaker, are desperate for that support, desperate for that help, and yet this government ignores it. They ignore that problem until it becomes so big a problem, Mr. Speaker, until it becomes such a problem that a criminal act is committed, they're dragged before the courts, and the courts are unable to deal with it. And what have they done? Well, you know, the Minister of Health and the Minister of Community Services know full well what's being done. Is that the right answer? You know what? I would argue that judges are frustrated. I used to see as a Crown Attorney years ago, Mr. Speaker, this very point. People who would be coming to court day after day after day because they had mental health issues that weren't being addressed, either because they weren't taking their medication, or because the medication wasn't appropriate, or because the supports weren't in place. You particularly saw it over the Christmas holidays, where maybe they didn't have the support of family, or maybe that the support staff weren't available. But generally speaking, it was not uncommon to see it on a regular basis. These people would come into court 4, 5, 6 days in a row until finally there was something done. But the resources of the courts, the resources of the police, the resources of the communities were being dragged into having to address this problem in a reactive manner instead of in a proactive manner. And we still have the problem today, Mr. Speaker, where the government is failing to provide those services, failing to provide those supports. I think they're called action teams, Mr. Speaker, in the Involuntary Psychiatric Treatment Act. I think there's one in the province right now, an action team. But, Mr. Speaker, we need more. We need to see that as a way of saying, here are people that we're going to be putting into our community who have mental health issues. They need our help. They need assisted living. They need housing. They need social workers. They need people who are willing to work with them to ensure that they can live a successful life, however you define that, that they can ensure that they are going to be able to live life to the fullest. Maybe that's working. Maybe that's working part-time. Maybe they're not able to work, but they're able to still have an effective and a successful life, Mr. Speaker. But the fact is, it takes an investment from the government to ensure that happens. And when we don't have it, what we end up getting are people that end up running into the law, committing crimes, showing up in court, and the courts are not equipped to deal, Mr. Speaker, with the issue of people who are before the courts because of mental health issues. Yes, a crime has been committed. The court sees, it's the old story that justice is blind. Anyone can show up in the court who commits a crime, public mischief, damage to property, theft under $5,000, something more serious even. But, Mr. Speaker, the court sees these people and they say, we take the individual who shows up before us and we deal with them. If they understand the difference between right or wrong, then we are going to try them in court, and if they're found guilty, we'll provide them with a punishment like we would anyone else. That might be jail, that might be probation. The problem is, Mr. Speaker, when you have mental health issues that are the underlying root cause of the problem, it isn't enough just to try them and punish them. because the fact is that we're probably not going to send them to jail. Jail is probably not appropriate for them in those circumstances. They're going to be back out on the street, and again, without the supports, they're going to be back again, and reasonably soon. And that is what this government has failed to do, and what we have seen with regard to those two well-known cases in the past month and a half or 2 months, Mr. Speaker, that's the tip of the iceberg. Those are the two that the media have caught on to. I would suggest to you that for those, each one of those cases, there are thousands more every year that the judges and the legal aid lawyers and the prosecutors and the police are seeing. And they're seeing it because they're frustrated with the lack of support they're getting. And you even saw that in the Crown Attorney in the case of the most recent case, a week and a half ago, Mr. Speaker. You saw the Crown Attorney say, I don't have a problem with bringing someone here to explain what they're going to do. In this case, it was the Minister of Community Services. But, Mr. Speaker, they did that because he was frustrated as well. He's seeing it on a regular basis. The people involved in the system are seeing a lack of support for these people, a lack of proactive intervention and help and housing and guidance and support that is needed to ensure that they are able, as individuals, to lead a life that is successful, again, no matter how you define that. Well, Mr. Speaker, this government fails to do that, and they wait until there's a problem. And then, Mr. Speaker, we see why this Justice Administration bill should include a clause that actually has a mental health court in it. Because, Mr. Speaker, it is important that Justice Administration is more than changes to the Condominium Act or changes to the Vital Statistics Act, Mr. Speaker. Justice Administration should be about a system administering justice that works for all Nova Scotians. That is what this government has failed to see, not only in this bill, but in the legislation that they bring before this House now, and they brought before this House in the last 7 years. And yet, while they stand or introduce legislation here that tinkers with that or changes this, or because a bureaucrat says we need to amend this so that we can go ahead and do what we need to do, the real problems that are facing Nova Scotians fail to be addressed, Mr. Speaker, and here again is another example of a bill that frankly is irrelevant to 99.9% of Nova Scotians, and the problems that we are facing in our justice system are ignored by this minister and this government. Thank you.
The Honourable, the Leader of the Liberal Party.
Thank you, Mr. Speaker. As Justice Critic, I wish to speak very briefly on Bill number 21, an act respecting the administration of justice, version 2006 A, B, or C. I'm trying to remember which one, but Speaker, since 1999, we've repeatedly seen these Justice Administration Acts, and as was mentioned by the previous speaker, they were used to show up about once a year. Then it became once a session, and in this case, I believe we've had one each session, which is 3 in this case, so I believe this might be a 3rd one, and today a new one was announced, so I think we actually have the possibility of seeing up to 3 Justice Administration bills on the order paper all at once. Speaker, it does beg the question of how this legislature can pass legislation and within a matter of months have to be back with a bill to amend legislation that was passed here. It begs me to question as to whether we're rushing our way through some of these bills, whether we're not allowing the law amendments process to be used in a more efficient manner in such a way that we're better posting notice of these bills, that we're allowing ourselves better chances to review the implications. But you know, this is not a critique of the hardworking civil servants who work on this legislation or ledge council, but you know, clearly this is becoming a matter that obviously needs some consideration, the fact that we're doing it each and every year, and the fact that it's coming so shortly after legislation has passed this House. So I would hope that the Minister of Justice would turn his mind to this matter as to, is there something that we can do to improve the legislative process here in the House of Assembly, so that if there are new legislation, that we catch any possible faults with them during the process here in the House, rather than having to have amendments being brought in at a later date. But with that, Mr. Speaker, the Minister has already indicated some of the relatively minor changes taking place under this legislation. I think there's at least 2 more Justice Administration Acts to go, possibly this session, so I'm sure we'll have much more opportunity to speak at that point as those bills continue to move forward. And we certainly look forward to seeing what comes out of law amendments and whether there's any changes to the Justice Administration Act that need to be done in fixing previous legislation. Thank you, Mr. Speaker.
Thank you. The honourable member for Halifax-Shabukto.
Thank you very much, Mr. Speaker. The Honourable the Minister of Justice, in speaking to his Bill number 21, characterized it as having several amendments. He said it was a housekeeping bill. I take it by that he's suggesting that he has found some dusty corners and has attempted to make them clean. Mr. Speaker, I'm a fellow who admires housekeeping. I'm a fellow who goes in for it myself. I wash dishes, I fold the laundry, and I hang up my clothes. But the object of this, not just in my domestic arrangements, but in this chamber, is to try to bring some clarity, some cleanliness, I suppose, to follow through on the Honourable the Minister's word, to the state of the province's overall laws. I have to say that I find myself in serious doubt, having read Bill 21, that we're actually going to accomplish that through this particular bill. If the object is to clean things up somewhat, then I'm very much afeared that we may be creating just a little bit more mess. Now, when I look at an omnibus bill like this that tries to cover off odds and ends in half a dozen statutes, I have to wonder whether there's some theme that emerges. Why is it, we have to ask ourselves, that these particular 6 statutes are focused on? Why is it that these particular parts of these statutes are focused on? So at this point, when we're looking at the principle of the bill, we have to ask ourselves, is there something that can characterize the bill as a whole? Now, the minister said, well, it's just housekeeping. But I wonder if we might not just think about something else that tends to characterize this bill. And you know, it's not, unfortunately, this bill alone. When I look back on several of the bills that have come forward in this House from the government opposite over the last year or two, I'm struck by something that seems to me not to be a desirable characteristic of legislation. The problem is that the bills have tended to place increased reliance on the regulatory powers of the Governor and Council rather than to come to this legislature with a full range of specifics that say in understandable detail what the bill is about, what the full ambit of the legislation is, how we were to understand it, how the public is to understand it. Why are we nudging government more in the direction of decision by the Cabinet? Clearly, this is something that's convenient for a government that's in a minority position. What it means is that if it can persuade a majority of the members of this House to grant it wide regulatory making powers, then those powers can be exercised by the Cabinet, by the party that, even with a minority, is the party in power. And really, when you look at the kind of legislation that's come forward from the government, it hasn't really, in some measure, mattered to the government that it is a minority. Not very much, anyway. It's not as if the government had a vision for the transformation, for the positive transformation of Nova Scotia society that it wanted to put forward in legislative form. Essentially, for this government, being the government is about occupying chairs around the cabinet table. It's about appointing people they know to agencies, boards, and commissions. And it's about passing regulations, some of them contractual in form, some of them otherwise. For that, if that's the agenda, being a minority, is an inconvenience and not much more. Once a year, it's true, a budget has to be passed and adopted. But apart from that, if the essence of the government that they are giving Nova Scotians is a government from the cabinet table, then we should look somewhat askance and very suspiciously at bills that come to us and invite us to give a lot of regulatory making power to the minority cabinet. And in place after place in this statute, that's what we find. What we find is an attempt to give more regulatory power to the cabinet. Now, to the extent that I can understand the various provisions that are in Bill 21, they don't, for the most part, with one exception I'll get to in a moment, they don't appear to be of a hugely serious consequence. It looks as if the ambit for exercising this increased regulatory power is not necessarily going to be open to a huge amount of abuse. But at the same time, we have to look at it and ask ourselves, is this the direction in which we want our government to move? We read frequently, with respect to the federal government, critiques from professional political scientists of how cabinet government, which is supposed to be responsible to the legislature, to Parliament at the national level, is becoming more and more like the United States federal government with presidential powers. There's talk about the centralizing of powers in the PMO or the PCO. Is this something we wish to see replicated here? Unfortunately, we've already gone some distance down that road. And when we see clauses that essentially give a regulation-making power to the cabinet that says that it can define any term that isn't otherwise defined in the Act, or that it can exercise powers that really don't seem to be limited by any very precise criteria, then I think you have to ask yourself, what is it that we are being asked to nudge our government towards? Does it make sense to have a regulation-making power that says the Governor and Council can make regulations respecting any matter the Governor and Council considers necessary or advisable to effectively carry out the intent and purpose of this Act? Now that, you couldn't imagine broader words than that. And imagine at some point a regulation that might be challenged in court. Now, if that is challenged, what is a plaintiff going to say if that's the regulation-making power? Well, the Governor and Council failed to take into account relevant considerations or relevant facts. The answer of the government is going to be clear. We could take into account anything we felt like it because the legislature told us we could. Don't tell me we had to apply criteria. Don't tell me we had to be objective. Don't tell me we had to do some investigation and arrive at some finding of fact. This is an astonishing kind of power. Now, it may be that tucked into the Public Archives Act, it's not going to do a lot of harm. But you know, this is not the only place that this kind of provision shows up. So I wish really to sound an alarm, and I think perhaps not for the first time in this chamber with respect to this point. I want to put on record that this is not a desirable way to go, that we should think long and hard before this chamber, where the majority of votes are not on the government's side of the divide, we want to think long and hard about whether this is the kind of power we wish to see exercised by a cabinet. As I say, The Honourable the Minister is telling us this is housekeeping and that it's just going to clean things up. Well, I have to say, this doesn't look to me like folding the laundry and washing the dishes and hanging up the clothes. Now, I have a second point. No. I have a second point about this bill. And the problem, again, is not something that's confined to this bill. It's something that we see in many pieces of legislation that come in front of this House. And it has to do with what are titled the explanatory notes. Mr. Speaker, there are, I believe, about 7 members of this legislature who hold law degrees. 5 of them happen to be in our caucus. But, you know, one of the things about reading bills is that you shouldn't have to be a lawyer to read the bill. I mean, most of the members of this House are not lawyers, nor do we expect them to be. But you know, one of the aids for non-lawyers when it comes to reading legislation is meant to be the explanatory notes that go along with the bills. Now, I'm not attempting to speak on behalf of all the non-lawyers in this House, but I would be surprised, since I am one of the lawyers and I read the explanatory notes and I'm no further ahead, I would be surprised if all the non-lawyers were able to read the explanatory notes and find themselves to have a firm and detailed grasp of what this bill is all about. And it's not just this bill. And this is a problem with a whole variety of the statutes that we find coming across our desks. And I'm particularly worried when it comes to something like the disposal of Crown lands. There is included in this omnibus bill a section that has to do under the Land Titles Clarification Act with ungranted Crown land. And when I read the 2.3 lines that are offered to us in explanation of what then follows on 2 full pages of the bill, I am no further ahead. It just doesn't tell us what's going on, nor have I heard an explanation from the Honourable Minister that would give us examples of how he expects this part of the bill to be applied. Indeed, I have to say that when I read a piece of legislation in which a structure seems to be put in place to allow the Cabinet to move to grant Crown lands to what's called facilitate the economic and efficient reconciliation of the Crown's interest in certain ungranted land. The reconciliation. I have to say, I'm a little bit worried. I ask myself, I ask the members of this House, I ask the Minister, are we being asked to put in place some kind of mechanism that will facilitate some particular land transfer in some particular part of the province that we may come to regret someday? And if not, could we have, please, a solid example of how it is that the Minister imagines that these clauses are going to be used? What is this power for? What does it do? Well, the explanatory notes don't tell us. The so-called explanatory speech, or what should have been from the Minister, doesn't tell us. I'm left here scratching my head, and I'd be surprised if other members didn't do the same. So now, again, if this is going to be a housekeeping bill, addressing cleaning up some dusty corners in an efficient way, I'd like to know how. I really would like some explanation that tells us what is it we're being asked to do. Because we have the power, we have the votes. We're the ones who are being asked to say yay or nay, as the case may be, with respect to this bill. The government has control, even in a minority position, of the legislative agenda. They can decide what bills they want to introduce and what bills they want to call 4 days a week. All we can do is try and understand what it is that they're asking for and try and make a judgment as to whether it's in the best interests of the people of Nova Scotia. I don't think that's too much to ask. I think, in fact, it's the neat, appropriate, housekeeping way to go about dealing with bills when they come before us. Now, I'm prepared to suspend judgment until I get more information. I'm asking for information. But I'm mindful that, I think it was 1913, the American writer Ambrose Bierce, in his wonderful little book, The Devil's Dictionary, defined a lawyer as one skilled in circumventing the law. What I don't want, Mr. Speaker, is to adopt laws that will make it even easier for lawyers to circumvent them. So, really, I'm puzzled, and I'm left with just these 2 points, but I think they're solid points about the bill, and I hope that no serious harm will be done if we adopt this bill, but I worry. And I don't think, in good conscience, we really should, in the end, finally adopt this bill when it comes before us at third reading, unless we really understand it. So, Mr. Speaker, thank you for the opportunity to place my concerns on the record, and I hope they resonate with some other members of this House who I think are really, like me, minded to undertake thorough housekeeping. Thank you very much.
Thank you. The honourable member for Halifax Clayton Park.
Thank you very much, Mr. Speaker. And it's certainly a pleasure tonight to speak on Bill 21, which is called an Act Respecting the Administration of Justice. And I think it is important that we look at this. I'd like to really follow up on the previous speaker's comments to some extent, because it's quite true that if you looked at the title of this bill, you would never imagine what sort of items are covered within it. You would assume that it's something from the Minister of Justice relating to justice. And, again, I'm not one of the lawyers in the House, but I'm certainly, able to read with great care. And going through this was quite a surprise to see areas that I would have thought would be under the other departments, Department of Environment or Natural Resources for Crown Land, or assessments under Service Nova Scotia. And I didn't hear in the explanation or preamble or in the explanatory notes anything that would really let me know how broad-ranging this bill is. And as you know, Mr. Speaker, in the House, where we each have our own, or sometimes many areas that we cover as critics here in opposition, it's easy to assume when you see a bill that's entitled the Justice Administration Act that perhaps it has nothing to do with the areas that we are responsible for. But certainly going through it, I saw a number of areas that I question as well why they're there. And it's unfortunate that the way we go about doing and passing legislation and debating legislation, there isn't more explanation of what it is all about. And I was drawn as well, because of personal interest in the riding of Clayton Park that I represent. I was certainly drawn to the area about Crown lands, because I have quite frequently raised in the House the issue of Crown lands in my riding that are known as the Blue Mountain Birch Cove Lakes. And it's a large parcel of 1,750 hectares that lies between the Clayton Park riding, Hammonds Plains, and Timberley. and is a wilderness area at present, which I have asked the House to look at. I've asked the government to look at it to be preserved under the Wilderness Protection Act. In the method that we currently use in the province, anything to do, any purchase or sale or trade of Crown lands takes place, the decision takes place at the Executive Council or the Cabinet level. And I've often spoken that that should be a much more public process. And the reason for that is that wherever we live in the province, if there's Crown land in your vicinity, you should have some say on its disposal or the change of use that would go with that Crown land. And in this bill, they talk about its historical use, in talking about ungranted land under the Land Titles Clarification Act. They do talk about what it has historically been used for, whether or not it's been used by the public as Crown land, and so on. What concerns me at present is that all of these decisions are made through orders in council, and the only way the public can find out about them is after the fact, by combing through the many orders in council that are, after a period of time, made public on the internet, and I'm sure you can go in person and see the records of those orders in council. And as you go through, there are numerous land changes that are referenced all over the province, and sometimes they're very insignificant and small and perhaps wouldn't have a big impact on the community, but other times they can be very major. And if you are, like many people in the province, watching land in your vicinity, in your community, and trying to protect it or see something done with it, you have to watch very vigilantly to see if something has been changed in the ownership of those lands. And I don't believe, Mr. Speaker, that it's correct that the citizens of Nova Scotia, who are in fact the holders of this public land, which is there for the use of the public. We like to use the term Crown land, which makes it sound like it's more owned by the Crown, but it is land for public use. And really, we should, as members of the public, and here in the legislature as those who represent the public, we should be making it a more transparent process so that if there is a compelling reason to change the ownership or trade because it's advantageous to the province or the people of Nova Scotia, then that should be made public, and we should have no problem taking that through a public process before the decisions are made. So that concerns me because, as the member for Shabukto mentioned a moment ago, certainly we wonder when you have a bill that includes everything but the kitchen sink, which happens occasionally with these omnibus bills. The Financial Measures Act is another good example of one never knows what might be found in the Financial Measures Act, as the finance critics well know. It's concerning that there could be things being included here that we have no explanation for. And in this section dealing with ungranted land, it talks about the province having the right to sign off its interest in such lands. Now, I am aware that when the province went to the new digital system of registering properties, there was some confusion here in HRM at least about what lands were Crown and what wasn't. And that may be, in fact, what is behind this whole section. What had become clear was that some people, when they were using this new system that had just gone online, were finding that their properties, which they had duly purchased in some time gone by, were actually showing up in the database as Crown land. And that meant that each time a property sold in any swath of that land that appeared to be Crown land, it would require cabinet approval to let this land be sold. And that it was sort of an anomaly, but I gather it was land that had never properly been registered as being sold. And there was a big swath of it in Clayton Park West that went up through Rockingham from the Bedford Basin. I understand up Ochterlony Street in Dartmouth was listed as Crown land initially. I mean, areas that have been settled for a considerable length of time, and those properties are clearly in the hands now, and have been for many generations, even in some cases, of private landowners. But it created some difficulty in terms of the lawyers that were arranging those transactions and sales. And perhaps this is the government's response to that almost anomaly that had occurred that hadn't been noted previously when we were using land deed searches and so on by legal assistance. So maybe that's it, but when there's no explanation, and on that section part 2, which deals with ungranted land. There is absolutely no footnote or explanation, and I don't believe any of us have any idea exactly what is the difficulty that they're trying to correct by adding this entire section into Bill number 21. And it does raise those questions, and again, if you're not a lawyer or you haven't had the opportunity to fully be briefed on what that is about, it I think raises a level of concern among members of the opposition. And, you know, again, we certainly don't feel comfortable being told it's simply, you know, housekeeping amendments and things that government bureaucrats are suggesting would make things more correct or appropriate for the work that they're doing, because it is written in a format that's very difficult to understand what is the underlying reason for making these changes. And I think that the footnotes, in fact, are really quite inadequate in describing that. In the footnote, which should be the explanation for this entire section under Land Titles Clarification Act, it says clauses, and this is a quote, Mr. Speaker, clauses 11 to 14 add a new part to the Land Titles Clarification Act, respecting the reconciliation of ungranted land that exhibits current or historical usage and has never been acknowledged as Crown land. Well, that doesn't make very much sense, I don't think, to the average reader. It certainly doesn't explain what the problem is that the province of Nova Scotia, the government of Nova Scotia, is now trying to correct. So it would be, I really think that there is a call here, I guess, that we ask that those explanations be a little bit more clear. They're really as obtuse as the bill itself. And I think that we could do a little bit better in describing that for the average reader. In fact, it isn't for the members of the legislature alone, but any Nova Scotian should be able to understand those explanatory notes and know what the bills are about. And that's just one section of this act, which includes quite a few others. I'm curious as well about Part 1, which is the Assessment Act itself, and these are little amendments apparently around the Assessment Act. And the clause in this one says that it's going to what's it say? It says, it talks at the very end that it's going to be something between property owners and the Assessment Services Division of Service Nova Scotia Municipal Relations. But my understanding is that in this very fall sitting of the legislature, we will be looking at changing the structure of the Assessment Services Division, and that it will no longer be part of Service Nova Scotia Municipal Relations. It's going to become an agency under the administration of the municipalities of Nova Scotia. So I'm a little surprised to see some amendments that are housekeeping amendments to that act, when in fact we should be seeing some major fundamental changes around the assessment services and the assessment structure. So that again just begs the question of what it's doing there today. And again, you know, better explanation or perhaps an opportunity for a little bit better briefing would help members of the opposition support things that perhaps have very good explanations to be brought forward and introduced as law. So with that, Mr. Speaker, I would like to adjourn debate this evening. Thank you.
Thank you. The motion is to adjourn debate on Bill number 21. Is it agreed? Great. The Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, I now move that the House now rise to meet on the morrow at 11 o'clock a.m. And the House hours will be from 11 o'clock a.m. till 3 p.m. in the afternoon. The order of business would be public bills for second reading.
Thank you. The motion before the House is for the House to rise and meet again tomorrow at the hour of 11 a.m. The House will sit tomorrow between 11 a.m. and 3 p.m. All those in favor of the motion, please say aye. Those against, motion carried. The House stand adjourned until 11 a.m. tomorrow.